Well, thank you for having me, Renee. I'm very excited to be talking to the folks here that have come tonight about wetland regulations and where we are with the current waters of the U.S. policy. I wanted to give you just a little bit more background on myself. I started working in wetlands in 1993. I'm a graduate of the University of Arkansas in biological studies with an emphasis in stream ecology. I work nationwide. I'm located up here in Bentonville, Arkansas, and I'm an active member of the Society of Wetland Scientists and the Association of State Wetland Managers, and managed to do a little bit with the Society of Freshwater Sciences. A lot of what I'm going to say comes from material that I've researched and studied through webinars with the Society of Wetland Scientists and the Association of State Wetland Managers. That being said, the opinions I've developed are solely my own and don't represent any organization, and any errors are all my own. Our outline tonight, I'll be talking about the history of wetland regulations, a bit about the legislative and judicial framework. We'll compare waters of the U.S. versions. You'll have a thorough understanding of what the current waters of the U.S. status is, and then briefly we'll talk about some future developments, things coming down the pipe. We're going to go back as far as 800 years earlier in the Magna Carta in 1215, where they debated in the Magna Carta, which is a royal charter of rights agreed to by King John of England to make peace between the unpopular king and a group of rebel barons. So this is where they debated ownership of waters and where the use of water for commerce purposes and needing to protect access to water because of commerce began. We're going to go ahead and skip 500 years up to our Commerce Clause of the U.S. Constitution. This is where power was allocated to Congress for regulating commerce among states and with foreign nations and Indian tribes. It granted authority to our federal government to have jurisdiction over navigable waters in fact. And this is all going to develop into our current Clean Water Act, but I just wanted to let you see the development of this process. So what did they mean by navigable waters in fact? Basically, can you float a boat in it? The rivers, streams, and lakes were used for shipping and transportation. And in the late 1770s and early 1800s, rivers were very important for interstate travel and commerce and for national defense. Most emphasis for this Commerce Clause was placed on the navigable in fact. And as you'll see, definitions and determined intent are common themes when you talk about the legal world, when you talk about court cases and what laws mean. So we're going to skip ahead another 100 years to another seminal act called Rivers and Harbors Act of 1899. Now, this act prohibited the construction of any bridge, dam, dike, or causeway over or in navigable waters of the U.S. without congressional approval. And this is the first mention in Section 13, where the Corps of Engineer permits are required for discharge of refuse material into navigable waters. These Section 9 is that first prohibiting the construction of any bridge over or in navigable waters. So Section 9 is currently administered by the Coast Guard and the Department of Homeland Security. And Section 10 is the section that also banned obstructions that impede the navigation capacity of any waters of the U.S. that is currently administered by the Corps of Engineers. And these are all to protect a strong federal interest in open commerce between the states besides national defense. In 1948, Congress enacted the Water Pollution Control Act to enhance the quality and value of our water resources and to establish a national policy for the prevention, control, and abatement of water pollution. And as you can see, the precursor to the Clean Water Act here, it was in 1956, Federal Water Pollution Control Act. And then another act called the Water Quality Act in 1965. The result of these sporadic legislation was a hodgepodge of law. 11 reorganizations and restructurings of federal agency responsibilities compounded the difficulty of effectively implementing the law. To solve these problems, the 1972 amendments to the Federal Water Pollution Control Act of 1956 restructured the authority of water pollution control and consolidated authority in the administrator of the Environmental Protection Agency, which was created by executive order of that president, the current president then, in 1972, which was Nixon at the time. Well, which brings us to this infamous day in June 1969 of the Cuyahoga River, which is in Northeast Ohio. As Cleveland emerged as a major center for manufacturing, this river became heavily affected by industrial pollution, so much so that it caught fire at least 13 times, most famously on June 22nd, 1969, which you see in these pictures. Helping to spur the American environmental movement, sparks from a passing train set fire to oil-soaked debris floating on the water surface. And I know we would all just be horrified if you see this picture off to the right, where the guy puts his hand in the water and it comes out that oily. Obviously, there were inadequate protection of the environment from the River and Harbors Act of 1899, which brings us to the 70s, which were a very important time for the development of environmental protection laws for all industries. And one reason is because there was a surge in the number of infrastructure development projects by the federal government, our highways, our interstates. And so along came the National Environmental Policy Act, NEPA, January 1970, all under Nixon's control. And then he also brought in the Clean Air Act, December 1970. And here we get to the Federal Water Pollution Control Act amendments of 1972. This is where the EPA was created by executive order, the Endangered Species Act of 1973, and the Safe Drinking Water Act of 1974. The reason why a lot of these acts came into play is because citizens did not like seeing their tax dollars being spent on projects that did not take into consideration environmental concerns, cultural resources, and endangered species. And along this way, development of wetland protections, President Carter had an executive order 11990 that was issued in May 1977. It was the first wetlands protection specifically for wetlands, but it only protected wetlands on federal lands. The exact language is each agency is supposed to provide leadership and take action to minimize the destruction, loss, and degradation of wetlands, and to preserve and enhance the natural and beneficial values of wetlands. This order did not apply, though, to private parties for activities involving wetlands on non-federal properties. So it was sort of a precursor to George H.W. Bush's promise of no net loss, his goal when he was running for election in 1988, 1989. So most of us think about the most current history has to do with what I term the pre-2015. So the Clean Water Act of 1972, which it was renamed in 1977, there were several seminal court cases that developed to get us to where we are today. One of them in the pre-2015 category is the 1985 Riverside Bayview Homes case. This is where adjacent waters were considered jurisdictional waters of the US, so adjacent to navigable in fact waters. Another case was another regulation was the Migratory Bird Rule in 1986. This is one of the reasons given to regulate isolated waters, anything that was proven to be used as a habitat for migratory birds crossing state lines. And now we're back to the commerce issues of a lot of money is spent on hunting. So they were going to regulate isolated waters because of migratory birds crossing state lines. And then another really big one, as you can see, the Wetland Delineation Manual was written in 1987 that we currently use, but is the Swank versus the U.S. Army Corps of Engineers. It's another Supreme Court decision. Swank stands for Solid Waste Agency of Northern Cook County. And in this decision, which narrowed the jurisdiction of the EPA and the Corps, isolated waters were no longer jurisdictional based solely on migratory bird use. And we'll talk more about the Swank decision, or the next one is the Ropanos, which I want to go into detail in the next slide. Another important part about how our wetlands are regulated currently has to do also with regulatory guidance letters that the Corps puts out. They're just like what they sound like, guidance letters and how to interpret the laws. So let's look at kind of the picture of what these different court cases actually covered. So the Riverside Bayview was a 9-0, so it was a unanimous decision among the Supreme Court justices in 1985 that included adjacent wetlands as within the jurisdiction of the Corps of Engineers. And then in 2001, Swank was a 5-4 decision that they isolated waters were no longer jurisdictional based solely on migratory bird use. And then we get to the Ropanos decision in 2006. It was a split decision that where waters of the U.S. encompass some waters that are not navigable in the traditional sense, but required certain flow restrictions. Now, this is Justice Scalia's relatively permanent flow is what Justice Scalia was saying should be regulated. A continuous surface water connection is another point that Justice Scalia brought in. And then Justice Kennedy brought in the idea of significant nexus to a traditional navigable waterway. So I want to bring up, as we've been talking about from the early 1970s, Nixon through many of through the Bush presidencies, we've had the 2006 Ropanos decision, whereas I mentioned Scalia defined waters of the U.S. to mean only relatively permanent standing or flowing bodies of water. And then Justice Kennedy brought in the significant nexus, which had to do, and I'll explain that better to you a little later in the presentation. You had to determine if a wetland alone or in combination with other wetlands in the region significantly affected the chemical, physical, and biological integrity of other covered waters understood as navigable in the traditional sense. So here we get to the Executive Order 13778, which was put forth by President Trump in 2017. And what he did, it's titled Restoring the Rule of Law, Federalism, and Economic Growth by Reviewing the Waters of the United States Rule. And what he was wanting reviewed was the 2015 rule, which was put forth by President Obama's administration. And so that was his goal when he got in, was to overturn the 2015 Clean Water Rule. But let's go back to what our definition of the Clean Water Act. What is the purpose of the Clean Water Act? It's to restore and maintain the chemical, physical, and biological integrity of the nation's waters. Now, there are different ways, let me get my pointer out here, that the regulations influence us. I can move the chat over, okay. Permits for dredged or fill material, which is Section 404, is under federal jurisdiction. That means the Corps of Engineers implements it. So this is anytime you have a development or you're doing something on your property and you want to fill in wetlands because you want to make it usable, you have to get a permit from the Corps of Engineers. Now, there are 3 states, New Jersey, Michigan, and Florida, that do their own program, and it's a pretty extensive thing. It's called a state assumption when they do what the Corps does for the rest of the states. There is the National Pollution Discharge Elimination System, which is another permitting program that's run by 46 states and 1 territory. And the way the states have any influence on what impacts their waters is through a water quality certification permitting program, which is Section 401 of the Clean Water Act. And again, this is the state's power to have influence and can influence the decisions of a Section 404, because a Section 404 permit may say, well, you have to get cleared with the state before you can get this permit. There's other areas that the Clean Water Act helps our waters, is providing funding for the construction of treatment works like wastewater plants. And then there's other controlling revolving funds. So it's like where the plant may get money to build or make improvements. And then once they regain or recoup that money that it was cost by passing those costs on to the users, then they have to pay it back to the government. There's all kinds of ways that the Clean Water Act has helped really do what its purpose is. And another thing that we need to talk about here is the idea of cooperative federalism. And that is where you have 2 types of governments. We have a state government and federal government that work together cooperatively with common goals and not work against each other. Move this, get it off this here. All right, so we're still back to the Clean Water Act. The question is, how are waters of the US defined? Well, back when I started working, it was a lot simpler. Even I worked back, like I said, in 1993. This is a picture of me helping do some waters of the US delineations for what we call the 2-ton loop, which brought treated Beaver Lake water to rural areas in Northwest Arkansas and to some of the cities. I know we had a water, it provided water to Centerton. And before that, folks were still using wells, and there was some concern for high nitrogen in their water. And if you had a child and things, you couldn't like give water to babies that has high nitrogen. So back in time, waters were either water bodies or wetlands. And we mainly looked at if they were tidal or navigable, if they had an ordinary high water mark, and if they had 3 wetland criteria: hydrology, soils, and vegetation. Well, with the confusing, complex, and time-consuming results and definitions based upon the Supreme Court decisions in 2001 and 2006, needing the significant nexus analysis, which was very broad. It included nearly everything. There was a need for, a lot of folks thought, to get more specific and not have these so many waters subjected to a case-specific jurisdictional determination that nearly always met the need. So to understand exactly how things develop, I want to give you a little bit of a review on the foundations of regulations. As most of you probably know, U.S. Constitution, we have legislative authority through Article 1, Section 1 for Congress to write bills that they send up to the president. He signs those, they go into law. And then the executive branch is responsible for day-to-day enforcement and administration of these federal laws. The executive branch is composed of, obviously, the president and his 15 executive departments: Department of Agriculture, Commerce, Defense, Justice, State. And they're joined by other executive agencies such as the CIA and Environmental Protection Agency, the heads of which are not part of the cabinet, but who are under the full authority of the president. The executive office of the president also consists of the immediate staff to the president, along with entities such as the Office of Management and Budget. So this executive branch includes more than just the president. But often these laws don't have all the details needed to explain how an individual, a business, or government needs to follow the law. So we go through what is called a rulemaking process. And there is another regulation called the Administrative Procedures Act of 1946, the APA, that regulates how that happens. When you go through that process, things are published in the Code of Federal Register. There's public notices. And then there, through the public notice and comment period is where the public, the public, gets to influence the outcome of these rules. And rules are really have the force and effect of a law, and their common name is a regulation. So what does the Administrative Procedures Act of 1946 look like? Well, the way it's set up, and this is an example using a state agency, but you could have the word federal here just as well. So you have to have a notice of proposed rulemaking. You have the initial text, or you publish the text of the regulation. There's a minimum of, usually for federal actions, a 60-day public comment period. Sometimes it's longer. The agency, state or federal, receive comments and come up with responses. If there's a major change, sometimes they have to republish it. And so sometimes there's decisions made. Is this a major change, or there's no change, it's not substantial? If there's a substantial but sufficiently related, sometimes there may be a shorter comment period. But eventually it has to get through all of this so that it gets published as a final text of the regulation. So there could be versions of it that get changed and they go back through the cycle. Finally, the rulemaking record is closed. And that's how our laws, this is a vehicle for law adoption and creation. Another thing we need to keep in mind with federal laws is that it has to go through the federal court system. As you can see over here, these are the states, but since we're dealing with federal laws, it has to go through the U.S. district courts. And then if there is an issue, one party is not happy with the decision, it goes to the U.S. Court of Appeals. And sometimes it goes all the way up to the Supreme Court. Sometimes that happens because different U.S. Court of Appeals have different opinions that may conflict with each other. And so the U.S. State Supreme Court is trying to unify how laws are interpreted. So this illustrates how many U.S. district courts we have. And if you look at the state of Arkansas, there's two. So we've got an east and a west side to the U.S. district courts. Like Iowa would have a north and a south. Texas has, as you can see, those gray lines, 4. But then the Court of Appeals is a combination of several areas. Let's say the 6th U.S. Court of Appeals is Michigan, Ohio, Kentucky, and Tennessee. And then the 12th Court of Appeals is a DC circuit, and the 13th is the federal circuit. And those circuits sometimes are known for reviewing specific types of court cases. For instance, the Clean Water Act may go through, the Clean Air cases may go through the federal circuit. And because they're real, it's tedious, there's a lot of details to it. And judges that have reviewed the regulations are more familiar with it than sending it through other avenues. Some exceptions are to this is that they may not go through the lower court. Some cases go straight through the appellate court or the Court of Appeals. So let's get, now that you know all that, let's get on to what are waters of the U.S. We're going to go through. Now, this next part to the presentation is shared from a fellow Society of Wetland Scientists member who works at a larger company, and he's employed a graphics designer to, pictures 1,000 words to show you the different categories. And his name's Matt Stallman. He's very good about sharing what his company has developed. So we do need to do a legal disclaimer, and it's a bit serious and still kind of fun. The presentation is for educational purposes only, does not replace independent professional judgment. It's been prepared by a presenter and his general background information about waters of the U.S. and the Clean Water Act. It's not given in summary form, not purported to be complete. You still need to get independent regulatory counsel if you're wanting to use these details for your projects. Things are specific. The statements and facts and opinions are those of the presenter and not anything Cattails doesn't pretend to endorse or approve or assume, and this presentation is not valid in Canada, the People's Republic of China, or interstellar space. And no waters of the US were harmed in the making of this presentation. All right, so let's get on to our next one. So here we are, we're going to go over all the different categories of waters of the US that have been involved in past and current regulations, all right? We've got the territorial seas. Most people know the territorial seas for the US extend 12 nautical miles from the baseline. We've got traditional navigable waters, waters in fact. So we know we can float a boat up there. They can be used for commerce, transportation, public defense, if we needed to fight through the seas. Perennial streams is a category of waters of the US. Perennial means flow occurs year round. It doesn't go dry. Those streams do not go dry. Intermittent streams, that's where the flow occurs with groundwater. So it's still can respond to some rainwater where the groundwater comes to the surface and flows. That's an intermittent stream. And then ephemeral streams. Ephemeral streams only flow in response to rainwater. There's no groundwater coming to the surface and exiting via a channel. Next, we have our impoundments of, let's say, ephemeral streams or perennial streams, any of those different categories. Let's see. I need to take this off. Okay. Next, we have a wetland that's behind a levee. So that's a different category. Oh, I know what happened. Let me go back. I didn't see it moving. Abutting wetlands. Abutting means it's adjacent. It's immediately adjacent. There's no space in between the wetlands. We talked about adjacent wetlands with one of those court decisions. Wetlands behind levees. Adjacent wetlands, no surface connection. Okay. Adjacent wetlands with surface connections. So I'm going to toggle back and forth. So you see those, see how they're touching different forms of the streams, ephemeral, intermittent, or perennial. And then adjacent wetlands with ecological or subsurface connection. It's a different category. And then we also have our isolated wetlands. And then we have certain wetlands that are, or waters that are used for certain purposes, isolated stock pond. And then we have a 100-year floodplain. So we've got some wetlands that are outside the 100-year floodplain. We have wetlands that are inside the 100-year floodplain. And then we have the farming issues. Now farming, I could do a whole presentation on the influence of the regulations on farming. You really get into the details about ditches and how they were made and how they were used, if you can clean them out. If they were created in uplands, it's okay too. If they're not, you can't reroute things. It's just, there's a lot of detail there. And then we also have snowmelt. Another category of wetlands that is in part of some of these regulations are what they call 5 similarly situated wetland classes. And these are geographically specific types of wetlands. You can kind of see Carolina Bay, Texas prairie wetlands, western vernal pools, prairie potholes. All right, so the Southwest post-Swank court decision. This is what was considered waters of the US, everything that's blue. If it was adjacent, it was within the 100-year floodplain. We had significant nexus that caused these adjacent wetlands that didn't have a surface connection, but did have an ecological value in the watershed to be considered jurisdictional. And what we're going to do here is I want you to keep your eye in this area right here, because it's going to explain some of the colors of this graphic. All right, after Ropanos in 2008, the Supreme Court decision, we had the blue area is jurisdictional, The gray is case by case, having to do with the significant nexus, the flow regime, and then the gray is the non-jurisdictional. So let's look at this. We've got isolated wetlands that are not jurisdictional. The gray ones, case by case. So if your project or your property fell in this area and you were wanting to do something with it, the Corps of Engineers would have to determine on a case by case if it was jurisdictional. So we're still here in the blue. We've got adjacent wetlands that are in the 100-year floodplain, 100-year floodplain, but not adjacent. That's case by case. See how this is working? Budding wetlands, those are jurisdictional. So what was the next version? Okay, with Obama's Waters of the US or Clean Water Rule of 2015, they tried to clarify some distances in those regulations. For instance, let's see. If a wetland was within the 100-year floodplain, but beyond 1,500 feet, this may or may not be jurisdictional. But if it was adjacent or abutting and within 100 feet within the 100-year floodplain, it would be considered jurisdictional. Or if it was adjacent wetlands, no surface connection within 100 feet of something that was considered jurisdictional. So you can see how it gets complicated. You need to know where the floodplain is. You need to know your distances. Let's see, anything beyond 4,000 feet from a jurisdictional, see the blue, ephemerals, jurisdictional, was not considered jurisdictional. So isolated wetlands that were beyond 4,000 feet were not considered jurisdictional. And these 5 similarly situated wetland classes were considered jurisdictional. You can't really tell from the gray, but it's the darker gray. You'll see it when it pops out. And then stock ponds, isolated stock ponds were not considered jurisdictional. Upland swales were not. Some ditches, sometimes if they were created within a wetland, they were considered jurisdictional. Or on a case by case, it was still a case by case in this ditch area. All right. Well, I'm going to go back to that. So this is in 2015. The Obama's 2015 Clean Water Rule was in effect for about 2 months, August, September, October, about middle of August to the middle of October. There was the Sixth Circuit Court had a, let me get to that one. The Supreme Court had a decision to see if this nationwide stay against the Clean Water Rule would stick. Did they have the jurisdiction to declare nationwide that the Clean Water Rule wasn't going to be implemented, basically? And that Supreme Court decision said that all litigation must begin at the U.S. District Court level, and they could not say that the stay, which means that it wouldn't be implemented, would be in effect nationwide. So how many U.S. District Court levels do we have? We have 94. Remember, nearly most states may have 1 or 2, about 50 states, 94. So all those court cases had to start at the U.S. District Court level, which means there's all kinds of opportunity for differences of opinion. Now the stay became invalid in February 28, 2018. So it took that long, nearly 2.5 to 3 years to figure out the stay that was put on the 2015 rule would have to go to a different. Okay, so this is what it looked like. If you look at the United States, we had a federal laws were being implemented differently depending on where the state lines were, which actually kind of blows your mind, because it should have been the same across the whole nation, but the way our system is set up, it wasn't. So in some states, depending on the status of the court cases, let's say wherever you started your court case, who you had joined with, some states attorneys would join with other states and would pick their would pick the venue, which route would they go, which appellate court area would they go, because they all have a reputation for either being stricter or less strict with federal laws. It's really interesting. So the blue is where the 2015 Clean Water Rule was in effect. So if you're a consultant, you need to know what the 2015 Clean Water Rule definition was. And then the green was all the pre-2015 regulations that I had shown you in green earlier. Well, then whenever the nationwide stay was canceled, that meant some people had to start over again and go through different avenues, but it flipped some of these colors, where before Oklahoma was kind of the only blue one over here around near us. Colorado was in blue. New Mexico is a whole different ballgame. There were 10 counties that had gotten involved in a lawsuit, and they weren't sure whether they should say that the 10 counties that were involved in the lawsuit should represent the whole state of New Mexico. I mean, that would just get to be a nightmare if you said, okay, well, these 10 counties have this definition of waters of the US, and then the rest not. So that was pretty complicated. And that really hasn't gotten resolved until just a couple of weeks ago. So again, we're still in between the 2015 and the pre-2015. And along came, and this was, let me move this out of the way so I can see. So everything became green on December 2019. So we went back, because the Clean Water Rule was, went through the court system correctly and got removed from the system, so to speak, as far as being a regulation. Now, so this is December 2019. So from December 2019 to June 2020, we were under the old pre-2015 regulations. Beginning in June 2020, we went into, let's see, sometimes it freezes up and I can't get to go forward. We went into Trump's version of waters of the US. And like I mentioned with the APA, the process that you get these rules made, there's a draft rule. So let's look at what his draft rule told us. Again, the blue is jurisdictional. So we still have navigable waters. Here's the perennial ones. Well, it drops out all this gray stuff, the ephemeral, isolated, adjacent, didn't mention anything about the floodplain in this draft rule. All the light gray is non-jurisdictional. These are not protected anymore, according to this draft rule. It still had abutting adjacent wetlands that were right next to perennial or intermittent streams, but that was it, or the seas. Well, after going through a review process, the actual rule that got published is what they call the Navigable Waters Protection Rule in 2020, and it added these details. You see the orange arrows means it's inundated by flooding in a typical year. And what this brought into play is definitions like typical year. So it's on an annual basis. Is it flooded? And it's still a little bit gray here as far as determining that, because sometimes when you have these projects or when you're needing to know, you don't have the ability to go out and just repeatedly make site visits. So you may have to go because of the schedule or whatever with the project, go see a site within a certain narrow window, and you can't just spend all year looking at it and making multiple site visits. It takes a lot more time and money to do that kind of thing. And then contribute surface water flow. That's another detail that was put into the Navigable Waters Protection Rule. So you have to see a physical surface area that would show flow or direct hydrological surface connection. So when you go out to, or when you're evaluating your property to see if it fits, if you have to have a permit to do any kind of changes to it, you need to be looking for these kind of things. And again, you look at all the gray. One of the biggest thing is the ephemeral streams. There's a lot more ephemeral streams out in the west, the arid west, where water flow channels occur just because of the rain, and they're real flashy. And so those areas are not protected anymore. Another little detail here is the non-adjacent wetlands that are not inundated by flooding, so they're not within some kind of floodplain area, are not protected either. Okay. So if you put these side by side, I mainly wanted to compare the pre-2015, which is what was in play before the 2020, after we'd already kicked out the 2015 Clean Water Rule. We have all these different categories. We have 4 categories for the 2020. The 2020 again drops out ephemeral flows, which is rainwater influenced only, and calls A2 waters, that's the way the regulations are written, only protects perennial or intermittent flow, and of course the territorial seas and traditional navigable waters. So it talks about lakes and ponds, and it also says adjacent wetlands are jurisdictional. They have to abut or have surface connection in a typical year. And then the pre-2015, you still have all this case-specific assessment of different flow regimes. Okay. Oops, too fast. All right, the significant nexus test is dropped out completely of the 2020 Navigable Waters Protection Rule. It is needed for all of these. These are the case specific, and it has to do with intermittent and ephemeral streams, wetlands adjacent to these kind of flow regimes, abutting to these kind of flow regimes, adjacent to relatively permanent waters, isolated wetlands. All this has to have significant nexus test. And what is that specifically? Well, it's where you evaluate 9 aquatic functions. And this is going to sound familiar to what Eric talked about last week. What are the values of wetlands? And this is where the reason why Obama, even his administration, went forward with the 2015 Clean Water Rule, is to try to tighten this down and not make it so broad. All right, let's look at these 9 functions. You only had to meet one of these to meet the significant nexus evaluation: sediment trapping, nutrient cycling, pollutant trapping, retention of floodwaters. That sound familiar from last week? Runoff storage, contribution to flow, export of organic matter, export of food resources, provision for life cycle dependent aquatic habitat for species located in the other 3 categories in this. Is there any wetland that would not meet this? I mean, this is one of the big values that we've always talked about, is attenuation of floodwaters, sediment trapping. That's why the significant nexus test is so broad and why people were complaining or needing something different. All right. One of the complications, though, with the 2020 Navigable Waters Protection Rule is the definition of typical year. It's kind of complicated. There's a 30-year records for 30 years on rainfall, and it's still up to some professional judgment to figure out, well, does it meet does this time period meet the typical year, or do we have excessive rain? Do we not? You know, there are 12 specific areas that are listed in the Navigable Waters Protection Rule that are non-jurisdictional, and I wanted to cover these just so that you knew, and to also give you a little bit more detail there, that there are some very specific waters that are not. So groundwater is not jurisdictional in the Navigable Waters Protection Rule. Groundwater is usually essentially considered jurisdictional by the states, the Department of Natural Resources, or the Arkansas ADEQ, that this is their jurisdictional. But this is also where some of the future controversy is coming in, because there's court cases dealing with some of this right now. Ephemeral features, we've already mentioned. Diffuse stormwater runoff, ditches that are not part of the other areas, prior converted cropland, artificially irrigated areas. These are non-jurisdictional. Artificial lakes and ponds that are constructed or excavated in upland or in non-jurisdictional waters. So how did these ponds or lakes come about? What was the history of the site before they were made? Water-filled depressions constructed or excavated in upland or in non-jurisdictional waters incidental to mining or construction activity. These are real specific to why some of those court cases came about. They were related to mining. Stormwater control features constructed or excavated. You see in the theme here in upland or in non-jurisdictional waters. Groundwater recharge, water reuse, wastewater recycling structures. All of this comes into play when you have very specific activities going on. And of course, wastewater treatment systems. And again, this is where we are as far as the Navigable Waters Protection Rule of 2020. You can see all the areas that we've been mentioning that dropped off and what has to be met to be considered jurisdictional by the Corps of Engineers, requiring a permit for any alteration, basically. All right, so what are our future developments? Well, you need to be aware of something they call the Congressional Review Act. It was enacted in 1969. Whenever there is a change in administration, there is a certain time period that it gives Congress, the new Congress, to change any regulations published after May, which is about 6 or 7 months in an election year. That's why you will see some of these regulations being pushed through quickly because they don't want to fall under the Congressional Review Act to make it easier to overturn them from one administration to the next. That is also one of the reasons why some of these cases are brought forward, saying they made it go too fast. They didn't follow correctly the APA, the Procedures Act, that caused for a certain length of time. Let's say if it was, I know one of the complaints about the Navigable Waters Protection Rule is that they did not have a long enough public notice and comment period for such a far-reaching regulation. They didn't provide enough time, and 60 days is really not a lot of time for our community to provide feedback. Other future developments, when President Biden came in, he published the Executive Order 13990. And I wanted to tell you what that was. That's titled Protecting Public Health and the Environment and Restoring Science to Tackle the Climate Crisis. It is an immediate review of agency actions. So not only is there the Congressional Review Act, this is the administration who's going to review all agency actions taken between January 20th, 2017 and January 20th, 2021. And this executive order revokes previous administration's executive orders. So what does that mean? Well, there's the 2020 Navigable Waters Protection Rule. That's under review. There were changes made that cut back or narrowed the state's ability in water quality certification, the water quality certification process for 401 permits. That's under review. There were changes in the mitigation rule. You can see it's a mitigation rule amendment that hadn't really been changed since 2008. That process that had developed from the rulemaking that had gone on from that is under review. Also in 2020, there were NEPA, National Environmental Policy Act that we mentioned. There were procedural provisions that were updated, and those are going to be under review. So what else are the future developments? There's more states that are wanting to assume or take over the Corps' responsibility with the 404 permit process. And Arkansas is one of those states. They have a bill with the House that's submitted. So it has to go through the legislature to decide if they're going to do that. State assumption is not something that you take lightly. It takes staff and money and time. It's probably about it's a 2 or 3 year process to get memorandums of understandings with the other agencies to make sure that you're doing it right. So these are not complicated. These are complicated things. This is not something simple. Also, litigation to watch is the groundwater. There's lawsuits out there related to the influence or the discharge, say, of pollutants into a wastewater treatment well that eventually bled out into or flowed out into navigable waters that is eventually going to be visited by the Supreme Court. So we're keeping our eye out on legislation related to groundwater. It's usually only regulated by the states, but now that if it's determined that it pollutes navigable waters of the US, then could be that the Corps comes in and either fines or makes the people clean up or has some kind of regulation over that. Okay, the last thing I wanted to say is, this is a quote from Stephen Samuels, who is retired assistant chief. He worked in the Department of Justice for 31 years in the Environmental Defense section of the Environment and Natural Resource Division of the Department of Justice. And he said in one of the meetings that I attended that Congress has it within its power to determine the scope of the Clean Water Act. Despite 45 years of litigation over the scope of the act, three Supreme Court decisions that have gone every which way, Swank, Ropanos, they have only sown confusion that Congress has not been able to even begin to define what the Clean Water Act means. He felt, and he feels still, that it's really Congress's responsibility to do that, to write a better bill, to write the laws better, so that it isn't always determined by the Supreme Court in these decisions. And with the fluidity of the executive orders and things going back and forth, and people not knowing if their property fits within the jurisdiction of the Corps of Engineers, you can see how those are very hot buttons with landowners and landowners' rights, and it causes a lot of expense. And then the pull and the tug with flood protection and the value that wetlands do give us. But that's I'm ready for any questions if we have any.
Oh, thank you, Jodie. I'm just going to jump in and say thank you. That was amazing. And I just wrote down a bunch of questions, so I'm going to start off with one while some other folks might be typing theirs into the chat. About the Congressional Review Act, how long does, like now with the current administration, how long do they have to make a decision on whether or not to overturn some rules from a prior administration? They're reviewing from 2017 to 2021. How long, or is there a time limit for them to make a decision?
Well, I'm not aware about a time limit on making the decision. I just know that everything takes a lot longer than you think it would. And I was actually surprised that he could have an executive order that went that far back, because I didn't understand. I don't know all the intricacies. I'm not a lawyer. And so some of this is still kind of new to me when I see the developments. So I'm basically just trying to say, this is what's going on. I'm not exactly sure, and I don't have all the answers on that.
Well, thank you. There is a lot going on. It is so intricate and tedious. So see why it takes a long time. Another question, and this is a kind of a more lower level question from maybe a landowner's perspective. How do you determine as a property owner, and I'm guessing it would be some kind of a survey, but how do you get those measurements? You know, there was some things about, 100, I think it was 100 feet or 4,000.
Yeah, 100, 4,000. Well, you can go on to Google Earth and you can do some of that measuring yourself if you can see it. The problem with the actual implementation of the Clean Water Rule, which, like I said, was really only in play for about 2 months. So not too many people, got to do that really, unless people are really on top of things. But had to do with, you couldn't get on other people's property necessarily to see if they had a jurisdictional water that you were close to. And so things were going to have to be done through the desktop and not necessarily verified in the field. And some of these regulations are written so that you really need field verification of the characteristics, say to get the flow regime or to know where the ordinary high water mark. If you've got a forested section on the property, you can't see through aerial photos what's underneath those trees. So it's still a little bit of a guessing game. And like I said, it was really only in play for 2 months. And then by the time the stay was pulled off of it, everything went back to the pre-2015, and then the 2020 came along and came into play. So.
Okay, and this may be a related question or very basic, I'm not sure. The subsurface connections, what, you know, if you can't see those either, what is an example of what that would be? The subsurface, ecological and subsurface connections between two
well, the way you figure out subsurface connections is they can do dye test, and people who study karst topography will, let's say you drop some kind of dye, you can find it through sensors further downstream. You can see if something is connected by collecting that information downstream. There's something real close actually here to where I live I live close to Centerton. There's a site that they were concerned about the cave fish, which is south of us in Cave Springs, and that the springs that are way up here in Centerton, the U.S. Fish and Wildlife Service are connected with the cave fish in Cave Springs. And so they were trying to be really strict on having any kind of pollution going into the ground and making sure everyone was keeping their construction sites really clean. But the subsurface connection is something that specialists measure through dye studies.
Okay, thank you. Quinn has a question that she wrote in the chat. So I don't understand why there are federal regulations that some states are exempted from. Is that correct? Or is it that the states have more comprehensive rules that incorporate and then go beyond the federal rules?
Oh, Quinn, this is a great question because I was wanting to bring this point out. And this has to do with state assumption. Can we take over what the Corps is doing? Do we want to be stricter than what the Corps, the federal regulations are? Do we want to be less strict? It all depends on what the state is wanting to do, really, if it seems like maybe positive or narrows the jurisdiction. But some states have laws that say they cannot protect their natural resources any stricter than what the federal law is. So there's a bit of a domino. If you're wanting to get stricter than what the federal laws are, then you have to change your state laws first. And then, let's see, so are some states not exempted from federal regulations? Is that correct? I don't think so, but it's really kind of complicated, and it's how their state laws are written. It could be true in some cases, and in other cases it's not. And it also plays into that definition of cooperative federalism, where they work together. The state can say, well, the federal law is this, and this is how it's going to be in our state. It helps protect, but then there's also the state with the water quality certification can be innovative with how they regulate, or if they see things that need to have higher protection, there's still state laws that you have to follow if you're a developer or you're doing some kind of activity. I know Tennessee has a lot more protections for different species. They have a unique geological formations that has caused different species to develop in their state, and they do have a lot more endangered species and threatened species protections on the state level than you see in other surrounding states. But it really, we are a reflection of the people in the state. So it's people getting involved. We are our government, basically. So you have to get involved. I'm not sure if that answered all your questions, Quinn. It's complicated, basically.
Boy, that's a truth. Yeah, as she goes on to say, you know, isn't everything eventually connected? Pollutants are poured into the soil. It'll eventually make it into some waterway somewhere, right? So
right.
Yeah.
There are methods to managing hazardous waste, and that's not my specialty, but I know they have ways of treating things. That is one way, like Eric was talking about last week. Certain plants can uptake pollutants and turn them into things that aren't as bad, but then also they can sequester the pollutants and be a pollutant themselves, and they have to be treated, handled properly.
Okay. Another question, is there, can you tell us about any pending or upcoming current Arkansas issues or court cases that are going on either nearby or somewhere in the state?
The big one is this state assumption. I hadn't heard of it till, I don't know, a couple of months back. It was written up by a law firm letting people know that there was this House bill being submitted that would need to go on up through the legislature. And I don't understand everything about the whole process, but I just know that Florida just got through their process of assuming the 404 permit program, and it took years and was a lot of work. And so if the ADEQ, the Arkansas Department of Environmental Quality, starts administering that permitting process, it'll be a whole new thing to learn and to figure out. But that's the biggest thing, is Arkansas is talking about assuming the 404 permit program. Other than that, I can't think of anything real specific to Arkansas. They did downlist, and this is something that I specialize in, the American burying beetle. I was actually on Facebook talking to the Division of Natural Heritage, had posted something about the American burying beetle, and I was kind of getting in there talking. Well, it isn't endangered anymore, it's threatened, and it's federally listed, but the state doesn't protect it any more than what the feds do. And the only known population is at Fort Chaffee. And so any private lands that have developments, you're not required, that may be near Fort Chaffee, you could have ABBs, American burying beetles, but it's only the federal land there at Fort Chaffee that's protected now and requiring surveys. So that's really kind of something new and different. And it's just started, it was published last fall, and the season for doing those surveys starts here in May, as soon as the temperatures get warm enough for the beetle to start being active. So that's a big change. And some people may or may not know that. It looks like we've got a couple more messages.
Couple more messages. So California has stricter air pollution laws than the United States, but there are currently representatives trying to stop California from having laws that are stricter laws than the federal laws. Is that true of water as well?
Right, that's right. There's the debate. Should we be as strict as US, the federal laws, or try to take more control and not be as strict? You know, it's a big debate. That is our federal cooperative federalism. And there's all different kinds of federalism. Do we work together? Do we not work together? So that is the tug and the push and the pull between state and federal.
Okay, and Quinn says it sounds like state assumption means Arkansas is trying to wrestle control of its water regulations, and not in a good way. So.
I'm not sure. I don't want to leave you with that conclusion about not in a good way. I don't know, because since I just was figuring out that they were doing this, I haven't read enough to know where they're headed with that.
Thank you. Jodie, unless there's any other comments or anyone has any other questions, we're a little after 7 o'clock already, and we can wrap it up. Unless there's any other questions, you can type one last one real quick.
Eric was pretty quiet. I'm sure there's something he thought I could have done a better job of. Was there anything you didn't understand? Because I was really wanting to make this something that everyone could understand.
Yeah, no critiquing here, Jodie.
Well, it was fun to get ready for this, and I really appreciate you guys asking me. I think Eric recommended me. I love to talk about these kind of topics and let everyone have a taste of the world that I live in, because this is the stuff I struggle with and I advise clients on about how to move forward. And it is pretty complicated. So you can't really have a simple answer to any question. There's a lot of details that you need to know. And I say everyone get out there and get involved in your local government, you know, participate in rulemaking processes, read things, comment. You may feel like you only know certain things, but you really probably know more than you think. Common sense is what's needed. So get involved with common sense and try to help be a part of your rules, your laws.
That is excellent advice and guidance. Thank you, Jodie. And just if you haven't seen it, Eric is saying you did a great job.
Yeah, he's saving questions for
yeah, he'll get to you later, don't worry.
He'll get me. I might have made a mistake or something. Anyway, it was fun. I appreciate you guys.
Thank you everyone for being here, and Jodie, appreciate your time and sharing your knowledge with us. Thank you so much. Good night, everyone.
Good night.